If the Department of Justice was a house, say, that the Obama administration was inheriting, it could safely be classified as a real fixer-upper. It was essentially foreclosed on after having been trashed by its outgoing tenant, the windows smashed before it was even boarded up. Today, the prospective new tenant of this house, the Department of Justice, the person responsible for the contractors being brought on board to fix all the damage, he appeared before the Senate Judiciary Committee to explain what repairs he intends to make and what the House will look like going forward. The nomination of Eric Holder as Attorney General, he would be the first African-American Attorney General. This was supposed to be the most contentious of Barack Obama's proposed cabinet appointments. Republicans telegraphed for weeks that this was the hearing at which they planned to make their stand. The event itself was even held in the historic Russell Caucus Room, site of the Iran-Contra and Watergate hearings, perhaps in anticipation of the partisan fireworks. But tonight, the headline out of the Holder hearing is not the fireworks, but how the process of taking over this dilapidated house, this foreclosed-on House of Justice, has brought to the fore a lot of really scary and alarming stuff from the Bush era that is going to be with us for a long, long time. We just moved into a house, say, and you can sort of think of this as termite damage to the foundation. Some examples. First and most newsworthy was Holder's plain-as-day assessment of waterboarding. Unlike his two predecessors, Mr. Gonzalez and Mukasey, who danced around the question like Fred Astaire and Gene Kelly without the music or the charm.
I agree with you, Mr. Chairman. Waterboarding is torture. I also think I'm not at all certain that waterboarding somebody, torturing somebody, whatever technique you want to use, is necessarily going to produce the results that we want. What I've heard from the experts is that people will say almost anything to avoid torture. They will give you whatever information they think you want to hear.
Now that's refreshing. That was easy, wasn't it? Another big scary thing being left behind by the Bush administration is, of course, the prison at Guantanamo.
Senator, Guantanamo will be closed. The physical closing of the facility is something that can be done relatively quickly. The question is, what will we do with the people who are there now? That review that we'll have to go through to figure out who these people are and in what categories they fit will take an extended period of time. And I think that is the thing that will prevent us from closing Guantanamo as quickly as I think we would like. But I want to assure the American people that Guantanamo will be closed.
And then there's the question of what to do with Bush Department of Justice officials like John Yoo and Alberto Gonzalez, who injected politics into the supposed-to-be independent Justice Department, whether it was to fire U.S. attorneys who weren't doing the right partisan thing, or to give the White House carte blanche to do whatever it wanted by just authoring memos.
Well, one of the things I'm going to have to do, I think, as Attorney General in short order, is to make basically do a damage assessment and understand in a way that I do not now how has the institution been harmed. There has certainly been damage to the department's reputation. I'd want to know if, as a result of those actions, has there been any structural damage. I will be more than glad to come back to this committee and share with you what I have found.
So today's hearing ended up lacking juicy, partisan, combative fireworks that we maybe expected. It actually more closely resembled a trial of the Bush Department of Justice, a litany of all the things they have done wrong and left us with, and hard questions about how those wrongs should be righted. But there was a major piece of news looming over the hearing that appears possibly to be a victory for President Bush and his Justice Department regarding the warrantless wiretapping program. Today, a federal intelligence court issued a rare ruling. This is only the second ruling they have issued in the past 30 years. The ruling validated the president's power to wiretap international phone calls and intercept email messages without a court order, even when Americans' private communications are involved. The appeals court upheld a secret ruling made last year that essentially said that the national security interests here outweighed the privacy rights of those who might be targeted. What exactly does this ruling mean? What is this court that issued this ruling? And how significant was today's Eric Holder hearing? Joining us now is Jonathan Turley, professor of constitutional law at George Washington University Law School. Mr. Turley, thank you so much for coming on the show tonight.
Hi, Rachel.
I want to get to the significance of the Eric Holder hearing, but first I have to ask you about this intelligence court ruling. What is this court, and how significant is this ruling today?
Well, this has been a very controversial court. It is not a federal circuit like the Second or Third or D.C. circuits. It's created specifically for the FISA court, which itself is viewed by many, including myself, as being inherently unconstitutional. It was created for the purpose of circumventing the Fourth Amendment. So all the conservatives who insist that they believe in the text of the Constitution seem to love a court that was designed to avoid the text. And this opinion is wildly pro-government. It's astonishing how the court accepts all of the assertions made by the government, even saying that there was no evidence submitted to the contrary. Well, for the most part, this is a non-adversarial court. While there was a petition filed by the telecom company in this case, this is a court that basically hears only from the government. The court even went ahead and said, look, there might be abuses, but there could be abuses under the warrant system. There's one problem with that, and that is when you are abused in the electronic warrants, the standard warrants, you know it. When you're abused by the FISA court, you don't. And the government has been successful in preventing anyone from challenging by saying you can't prove that we actually intercepted you. So it's a very weird decision, but for the most part, it says nothing about the criminal allegations against the president. This case specifically dealt with a law passed by Congress. It is not binding on the question of what happened before that law when the president went at it on his own.
I think that is being inexpertly reported, actually even in the way that I introduced you before we got to you. This was a ruling on whether or not what Congress did in 2007 about warrantless wiretapping was a legal law, whether that law that they passed in 2007 was legal. This was not exonerating President Bush. This was not an assessment of President Bush's actions, right?
That's right.
Yeah, okay.
There's language there that helps them, but for example, this isn't even binding on the other circuits, and I expect many judges would strongly disagree with what this court said.
Unlike the bobbing and weaving of his predecessors as Attorney General, I have to ask you about Eric Holder's pronouncement today that waterboarding is torture. That's a direct sentence and a direct quote. He said this one day after a Bush administration official said, yeah, we tortured, and said that without euphemism. So given that context of what happened in yesterday's Washington Post, how important is it that Eric Holder just unequivocally said today that waterboarding is torture, and he doesn't have any bones about it?
I don't know if we can handle all this clarity after 8 years of ambiguity. It's really dangerous. The fact is, you put that up against what Mukasey said in his confirmation hearing, which seemed to be manifestly and intentionally false when he said he didn't know what waterboarding was. But, the problem here is there really isn't any question that waterboarding is torture. Nobody seriously believed that it was anything but torture. There are decades of cases that establish that. The tough question is the one that they didn't ask as a follow-up. It's not up to Eric Holder or Barack Obama to decide that waterboarding is torture. It is. The question is, what are you going to do about it? You've now acknowledged that a war crime occurred, but nobody asked him, are you going to enforce the law? Now, if he had been asked, would you enforce the law if murder had been committed by the previous administration, he would say, of course. So what's the difference with a war crime?
Jonathan Turley, professor of constitutional law at George Washington University Law School. Your clarity on this subject, I think, has helped the country. Thank you for joining us to talk about it tonight.
Thank you, Rachel.